I'm Stephen Morrissey, managing editor of the New England Journal of Medicine, and I'm talking with Aaron Kesselheim, an assistant professor in the Division of Pharmacoepidemiology and Pharmacoeconomics at Brigham and Women's Hospital and Harvard Medical School. Dr. Kesselheim has co-authored a perspective article on the recent Supreme Court ruling on patents for diagnostic tests. Dr. Kesselheim, we'd like you to walk us through some examples of what's been patentable in the past and what is now patentable. First, you note that laws of nature themselves are not patentable, but at some point the courts decided that one could patent the use of such a law in an inventive process. And this led to a proliferation of patents in the healthcare field. Can you give us some examples of patents that fell into this category?
Sure. First, let me say it's a pleasure to be here. I think that one of the key questions that the Supreme Court has struggled with in the area of patent law over many decades has been trying to balance this question of what is patentable regarding medical processes. It is fairly clear that laws of nature, abstract ideas, and other concepts are not patentable, although any process that a inventor might want to patent certainly would have these things involved in them. Any work or any inventive steps in developing a machine or developing any kind of device is going to use these laws of nature. So it's been a struggle for the court to try to draw a line between what is a patentable process and what is a law of nature. So one of the ways that the court tried to set down a rule to distinguish a patentable from an unpatentable process is by claiming that a patentable process is one that creates a useful and concrete result, and an unpatentable law of nature doesn't do that. But that's turned out not to be a very good distinguishing rule, because any process can be written in a way so that it creates a result. So as a result of announcing these kinds of rules, in the last couple decades, the number of process patents sought for in the medical realm has exploded, because savvy patent attorneys have figured out ways to write medical processes so that they describe useful concrete results. So there have been patents over diagnosing disease on the basis of results in genetic tests, patents on modulation of enzyme pathways, and all of these kinds of patentable processes are arguably, natural facts and natural occurrences that an enterprising researcher has discovered, but that doesn't necessarily mean that it's a patentable process that has been man-made.
The courts then developed the machine or transformation test. Can you explain what that meant? What sorts of processes it was seen to cover and what sorts it excluded?
Sure. The machine or transformation test was derived out of a case actually not in the medical field, and it was described as a way of trying to draw a better line between what is a patentable and what is not a patentable process. And what it basically said is that laws of nature and other abstract concepts, natural phenomena may be patentable, but they are only patentable when they are integrally involved in a man-made machine or lead to a process that leads to a transformation of matter from one state to another. And that merely stating the law or law of nature wouldn't be enough to get a patent. So theoretically, a patent that describes the process of diagnosing Alzheimer's disease on the basis of identifying genetic mutations X, Y, and Z would not necessarily be enough to meet either of those prongs of the test. So it tried to exclude those patents that sought to cover merely natural discoveries or natural correlations that might end up being too broad and covering too much of the basic materials of research, and in that sense preventing progress of science, which would be the opposite of what the goals of the patent system are, which are to increase experimentation and increase progress of science. And the thought is that anything that wasn't tied to a particular machine or led to a specific transformation of matter would be just too general and too diffuse to be patentable.
The recent decision in Mayo Collaborative Services versus Prometheus Laboratories, which is the case you write about, means that to be patentable, a process must now involve an inventive and novel application of a law of nature beyond well-understood, routine, conventional activity previously engaged in by those in the field. Can you interpret this court ruling for us? What's now excluded and what is included?
Well, this is an incredibly bold court ruling in that it goes against a great deal of thought over the last couple decades in the process field. Basically, it had seemed like anything would be patentable as long as you could write it in a way that it would describe a process of going from point A to point B. And now what the court has said is that if the process on which the patent is sought is merely a natural correlation or one that exists in nature, and the human element is merely usual and conventional activity, that's not going to be patentable. And that has direct implications for a great deal of patents in the medical field over discoveries, particularly in diagnostic methods. Whereas in the past, it had been clear that it would be patentable to patent a process of diagnosing Parkinson's disease on the basis of a genetic test, or a process of affecting bone resorption by modulating a certain enzyme pathway. Those kinds of natural correlations or already existing rules of science that an enterprising researcher happens to discover, this court ruling, and it was a unanimous court ruling, now says are not going to be patentable at all.
You refer to an earlier case over a patent covering the association between an elevated blood homocysteine level and the diagnosis of vitamin B12 or folate deficiencies. And you note that the ruling in the recent Prometheus case would have applied there. Given that patent was upheld, do you think the case will be revisited?
Well, this is a really interesting point, because these very issues that were discussed in the Prometheus case came up about 6 years ago in the case that you're referencing, which is the LabCorp versus Metabolite case, which was a case about a patent that described a method of diagnosing a vitamin deficiency by discovering that a patient has an elevated homocysteine level. And that was the process that it described, and that was the patent that was issued. And it came up to the Supreme Court, and there was a great swell of interest by intellectual property lawyers and by entrepreneurs and by the industry about whether or not this case might be a watershed case that would lead to the changing in the fields of what might be patentable. And the court, though, after it took up the case and heard the oral arguments, made the very atypical decision to decide not to rule on the case, leaving the patent intact. Justice Stephen Breyer wrote a very vigorous dissent in which he argued that this case should be evaluated and should be overturned because all it does is describe a natural correlation. And now, 6 years later, Stephen Breyer, who wrote unanimous majority opinion in Mayo Collaborative Services versus Prometheus, finally got his chance to make his perceptions into the law. So, but the question of whether or not this case will be revisited is probably not, by virtue of the court refusing to grant cert, or going back on its earlier decision, refusing to grant cert 6 years ago. The patent ended up being upheld. Under the current Prometheus ruling, that patent is probably not valid. Although at this point it would take another sort of de novo challenge of the patent in order to invalidate it, and it's unclear if there's any interest in any of the parties who might be affected by the patent to do that.
Are you concerned about the effects of the Prometheus decision on innovation, or is it not true innovation to begin with?
Well, I mean, I think it is innovation. I mean, obviously it's very innovative work to discover a correlation between drug metabolite levels and activity of a drug. And it's obviously very innovative to discover that a particular gene sequence is linked to a particular disease, or to discover that modulating a certain enzyme pathway can lead to clinical effect down the road. So all of these are extremely innovative. I think the question is whether or not the existence of a patent accurately or actively incentivizes innovation that leads to these discoveries, or whether the existence of a patent that might be obtained after the fact only serves to make things more difficult, because then the 20-year period of intellectual property control might prevent others from working on the same pathway. So I think that in the cases of these very basic science correlations and discoveries, I don't think that the promise of a patent is what is motivating many of the researchers in this field. And I think that weighing the risks of the patent and the risks of this monopoly right, I'm not sure that allowing patents in this area is good policy. And actually, by restricting this area from patenting, we might actually get more innovation down the road, because these barriers are not in place.
If the Prometheus decision does reduce industry's incentives to explore new biomarkers, for example, you recommend increasing public funding for the development of biomarkers. How likely do you think that is to happen?
Well, I think that it's always hard to encourage Congress to spend additional money, but I think that one of the ways that can both promote innovation and discoveries in this field, but not with the burden that might be imposed by getting a patent, is to devote additional government resources and public resources to researchers working in this field. Ultimately, I think that kind of work is, again, the essential discoveries that then lead to improved patient care, that then lead to potential discoveries of drugs or other devices that might modulate those discoveries. This is the essential science that we need to continue to grow our understanding of research and clinical care. So I think that devoting greater public resources to it is an extremely important public policy goal. And I think that there are plenty of other places where, in healthcare spending that can be made more efficient in terms of spending on research or spending on stuff that isn't proven to work and doesn't have good evidence behind it. And even a little bit of extra money towards these discoveries in basic science can help catalyze a lot of future progress and work in the field.
You've also been following another patent case that's been working its way through the courts relating to the patents that Myriad Genetics holds on the BRCA DNA sequences and their use in evaluating susceptibility to cancer. The Supreme Court sent that case back to the appeals court. Can you tell us a bit about those patents and give us an update on the case?
Sure, that's an extremely interesting case, and the Myriad Genetics case basically involves two different sets of patents that the company Myriad holds on the BRCA genes that are useful in determining susceptibility to breast cancer. They hold patents on the sequence of the genes themselves, and they also hold patents on the use of the gene sequences in diagnosing enhanced risk of breast cancer by comparing those gene sequences to other gene sequences. So in the original case, the court threw out the patents on both of those different aspects of the intellectual property. On appeal, the Court of Appeals upheld the gene sequence case, but also held that the method patents were not legitimate. And at the time that the Prometheus case was decided, the Myriad Genetics case had an appeal put up to the Supreme Court. So with the decision in the Prometheus case, the Supreme Court sent the Myriad case back to the Court of Appeals of the Federal Circuit to tell them to re-examine the case in light of the new decision. And what the outcome of the Prometheus case means is that those method patents that Myriad held that were challenged and had been found to be invalid are now almost definitely going to be found to be invalid and upheld as invalid. And so those method patents that describe the method of diagnosing enhanced risk for breast cancer on the basis of these genetic markers are probably going to be upheld as being invalid.
Are there other patent cases underway that are likely to have important implications for medicine, for healthcare?
Actually, the next big patent case that many observers think is going to come to the Supreme Court is going to be the Myriad case on the basis of the patents on the underlying DNA itself, which is not a method patent but a product patent that describes the patent on the genes. And I think it's going to be a really interesting case because, in the Prometheus decision, the court made very clear statements that they thought that these natural discoveries and these natural correlations are not supposed to be the subject matter of patents. And it'll be interesting to see whether or not they apply the same reasoning to the natural discoveries of the DNA that underlies the breast cancer risk and applies the same reasoning that they used in method patents to this product patent. So I think there's always one or two patent-related cases that come before the court each year. The Myriad case is probably another year or two out from reaching its way back up to the Supreme Court. But I think the next big case related to patents before the Supreme Court is going to be the question of whether or not DNA sequences, as in the Myriad case, are patentable.
Thank you, Dr. Kesselheim.